And this time, Judge David Attar from International Tribunal for the Law of the Sea will moderate this session. Good afternoon, Judge.
Good afternoon.
Thank you. Now the floor is yours.
Thank you. Distinguished guests, I would like to start first of all by congratulating Director General Lee and President Lee for organizing this 7th annual conference, which is a reflection of your consistent support for promoting the good order and peaceful uses of the sea. On a personal note, I'm grateful to be invited again to this series of conferences, which gathers an impressive list of speakers, and I hope that the discussion of this panel will be of interest and successful in the proceedings. I would like to start by informing you that the two speakers are online, and I would like to open the session by inviting Judge Tanaka to address us. Judge Tanaka, can you hear us?
Yes, I can hear you.
Excellent. Welcome. I suppose it's good morning where you are. Here it's the afternoon.
Yes, it's good morning.
Good morning. I would like to welcome you and to say a few words of introduction. But as I understand, most of you do have this impressive CV of Judge Tanaka. Judge Tanaka will be addressing us on the military activities or law enforcement activities, reflections on the dispute concerning the detention of the Ukrainian naval vessels and servicemen, an interesting case which took us considerable time and effort. Before I ask him to address us, let me say that Judge Tanaka is the professor of international law with specific focus on the law of the sea at the Faculty of Law at the University of Copenhagen in Denmark, and he has written single works which I trust people in the law of the sea know well. Judge Tanaka, I now give you the floor.
Thank you, Judge Attar, for your kind introduction. I thank that the host of the conference, Ministry of Foreign Affairs of the Republic of Korea, and organizers of the conference, the Korean Society of International Law and the International Tribunal for the Law of the Sea. I also thank the Secretariat for their support. It is my great honor and privilege to give a presentation at such an important conference. I'm sorry that I couldn't attend the conference physically, but it is my pleasure to participate in the conference online. Today, I'd like to consider the interpretation of military activities for the purposes of Article 298, Paragraph 1b of the UN Convention on the Law of the Sea by analyzing Ukraine versus Russia dispute concerning the detention of Ukrainian naval vessels and servicemen. Article 298, Paragraph 1b of the Law of the Sea Convention allows state parties to preclude disputes concerning military activities from the compulsory procedures for dispute settlement under the Convention. The optional exception provided for in this provision should be crucial because military activities at sea concern particularly sensitive strategic and security interests for both the flag states of warship and the coastal state. However, the Convention contains no clear definition of military activities. In practice, the distinction between military and law enforcement activities is not always clear-cut, because naval vessels and law enforcement vessels collaborate for diverse maritime tasks today. The question that needs further consideration is how an international court or tribunal acting under Part 15 of the Law of the Sea Convention can assess the nature of conduct of states for the purposes of Article 298, paragraph 1b. As the jurisdiction of an international court or tribunal relies on the consent of states, the consensual basis for jurisdiction is of critical importance in international adjudication. At the same time, the effective settlement of international disputes constitutes a primary task of an international court or tribunal. Here, a sharp tension arises between the need for the effective settlement of international disputes and the safeguard of consent of states. In my view, the tension is at the heart of the interpretation of the term military activities provided for in Article 298, paragraph 1b of the Convention. In reality, the question was raised in the dispute between Ukraine and the Russian Federation with regard to the detention of Ukrainian naval vessels and servicemen. Upon the ratification of the Law of the Sea Convention, both Ukraine and the Russian Federation precluded disputes concerning military activities from the compulsory procedures of international dispute settlement in accordance with Article 298, paragraph 1b. In the Ukraine versus Russia case, the International Tribunal for the Law of the Sea and the Annex 7 Arbitral Tribunal examined the question of whether the detention of Ukrainian naval vessels and servicemen by the Russian Federation would fall within the scope of military activities under Article 298, paragraph 1b of the Convention. It seems that ICLS and the Annex 7 Arbitral Tribunal took different approaches when assessing the nature of actions of the parties in dispute. By comparing the approach taken by the Annex 7 Arbitral Tribunal to that of ICLS, I will examine the interpretation of the concept of military activities for the purposes of Article 298, paragraph 1b. As a preliminary consideration, I'd like to briefly review the factual background of the Ukraine versus Russia dispute. On 24th November 2018, 3 Ukrainian naval vessels were navigating from the Ukrainian port of Odessa through the Kerch Strait to Ukrainian ports in the Sea of Azov. According to the Russian Federation, the Russian territorial sea on the Black Sea side of the approach to the Kerch Strait was temporarily closed, and consequently, navigation towards the Kerch Strait would be unlawfully crossing the Russian state border. On 25th November 2018, the 3 Ukrainian vessels crossed the border of the territory sailing towards the Kerch Strait, and the Russian Federation ordered the Ukrainian vessels to leave. 2 Russian border patrol ships, along with other Russian vessels, including at least 1 naval vessel from the Russian Black Sea Fleet, continued maneuvers to prevent 3 Ukrainian vessels from sailing toward the Kerch Strait. On the same day, Ukrainian vessels stopped in the anchorage area number 471, but subsequently they began to leave the area. In response, the Russian border patrol ships ordered the 3 Ukrainian vessels to stop. Furthermore, one of the Russian border patrol ships fired shots and hit the Ukrainian naval vessel, the Berdyansk. Then the 3 Ukrainian naval vessels and their servicemen were arrested by authorities of the Russian Federation. On the same day, the Russian authorities commenced criminal proceedings against the arrested servicemen and the detained Ukrainian vessels. In response, on 31st March 2019, Ukraine instituted arbitral proceedings under Annex 7 to the Law of the Sea Convention in respect of a dispute concerning the immunity of 3 Ukrainian naval vessels and 24 servicemen on board. On 16th April 2019, Ukraine further asked ICLS to prescribe provisional measures. The Russian Federation didn't appear before the tribunal. On 25th May 2019, ICLS prescribed provisional measures. In the arbitral proceedings on 24th August 2020, the Russian Federation submitted 4 preliminary objections in accordance with paragraph 5 of Procedural Order Number 1. For the purposes of the presentation today, we will focus on the Article 298, paragraph 1b objection. Subsequently, on 27th June 2022, the Arbitral Tribunal delivered its arbitral award on the preliminary objections. Against that background, first, I will examine the ICLS's approach to the interpretation of military activities. In this regard, the tribunal clarified its approach as quoted in this slide. According to the tribunal's approach, the nature of state activities is to be evaluated comprehensively, taking into account the relevant circumstances. Under this approach, eventually, a dispute as a whole is to be characterized either a dispute concerning military activities or a dispute regarding law enforcement activities. This approach can be called the overall assessment approach. Under this approach, it is important to specify elements that constitute the relevant circumstances. ICLS, in its order of 2019, examined 5 elements indicated in this slide. The first element concerns the type of vessels. An issue that arises here is whether or not the nature of military activities can be decided on the basis of the type of vessel only. As quoted in this slide, ICLS answered negatively. This view is in line with the 2020 Ukraine versus Russian Federation Arbitral Award concerning coastal state rights in the Black Sea, Sea of Azov, and Kerch Strait. As quoted in this slide, the Annex 7 Arbitral Tribunal, in its Arbitral Award of 2020, took a similar interpretation. Taken together, the jurisprudence seems to suggest that the military activities nature under Article 298, paragraph 1b, cannot be decided only by the type of vessels involved, even though the type of vessels may be regarded as one of the relevant circumstances. The second element concerns the characterization of the activities by the parties to a dispute. In this regard, ICLS accepted that the characterization of the activities in question by the parties to a dispute may be a relevant factor, especially in case of the party invoking the military activities exception. According to the tribunal, however, such characterization may be subjective and at variance with the actual conduct. Therefore, ICLS held that the distinction between military and law enforcement activities cannot be based solely on the characterization of the activities in question by the parties to a dispute. ICLS, in its order of 2019, evaluated the nature of the activities in question, focusing on 3 elements: conduct, cause, and context. First, As regards the conduct of the parties in dispute, ITOLOS denied the military nature of passage. Second, as regards the cause of the incident, ITOLOS focused on the failure of the Ukrainian naval vessels to comply with relevant procedure in the 2015 regulations and the temporary suspension of the right of innocent passage for naval vessels. In light of this, the tribunal took the view that at the core of the dispute was the parties' differing interpretation of the regime of passage through the Kerch Strait, and that such a dispute is not military in nature. Third, the tribunal examined the context of the incident. According to the facts provided by the parties, the Ukrainian naval vessels sailed away from the Kerch Strait. The Russian Coast Guard ordered them to stop and started chasing them when the vessel ignored the order and continued their navigation. It was in this context that the Russian Coast Guard used force. In this regard, the tribunal considered that the use of force in the context was a law enforcement operation rather than a military operation, and that the arrest and detention of the Ukrainian naval vessels by the Russian Federation took place in the context of a law enforcement operation. In light of this, ITOLOS concluded that prima facie, Article 298, paragraph 1b of the Convention didn't apply in the present case, and that prima facie, the Annex 7 Arbitral Tribunal would have jurisdiction to deal with the dispute. As regards the overall assessment approach, two issues merit discussion. The first concerns the mixed nature of the dispute. Normally, international disputes are multifaceted. As Judge Gao stated in his separate opinion, it seems that the detention of Ukrainian naval vessels and servicemen by the Russian Federation has elements of military activities and those of law enforcement activities at the same time. The question that arises here is to what extent elements of military activities need to be included in order to characterize a mixed dispute as a dispute concerning military activities for the purposes of Article 298, paragraph 1b of the Law of the Sea Convention. ITOLOS, in its order, remained mute on this matter. On the one hand, an extremely high threshold for the military activities exception will significantly narrow down the scope of the military activities exception set out in Article 298, paragraph 1b of the Convention. On the other hand, an extremely low threshold may broaden the scope of the military activities exception and may unduly restrict jurisdiction of an international court or tribunal under the Law of the Sea Convention. So there is a need to establish a reasonable threshold avoiding two extreme ones. In this regard, it is interesting to note that in the 2020 Ukraine versus Russian Federation Arbitral Award, the Annex 7 Arbitral Tribunal expressed the view as quoted in this slide. Here, it would seem that the Annex 7 Arbitral Tribunal interpreted the meaning of military activities under Article 298, paragraph 1b in a restrictive manner. The second issue relates to temporal elements of a mixed dispute. Generally, international disputes are dynamic, and their nature may change with the passage of time. In reality, the nature of a mixed dispute involving both military and law enforcement activities may change over time from military activities to law enforcement activities or vice versa. Therefore, there will be a need to take account of temporal elements in the assessment of the nature of actions of the parties in dispute. However, the overall assessment approach does not incorporate temporal elements of international disputes. As we will see next, the Annex 7 Arbitral Tribunal focused on the temporal aspects of the Ukraine versus Russia dispute. The Annex 7 Arbitral Tribunal stated that the ICLS approach is the correct approach to take in determining whether the military activities exception to the Arbitral Tribunal's jurisdiction can be invoked in this case. In so stating, it seems that the Arbitral Tribunal attempted to maintain the consistency with the order of ICLS. However, it is not suggested that the Arbitral Tribunal took exactly the same approach. There, the Arbitral Tribunal stated that it does not accept the rigid either-or proposition espoused by Ukraine. Nonetheless, either-or is an essential feature of the overall assessment approach. When considering the approach of the Annex 7 Arbitral Tribunal, what is of particular importance concerns a temporal element. In this regard, the Arbitral Tribunal made an important statement that characterizes its approach. This statement clearly refers to the changing of the character of activities of the parties in dispute. In fact, the Arbitral Tribunal thoroughly examined successive events in chronological sequence. According to the Arbitral Tribunal, the events which gave rise to the Ukraine versus Russia dispute can be divided into 3 phases. The first phase involved a confrontation between the militaries of 2 states. The Arbitral Tribunal didn't clearly identify the starting point of the first phase, but it seems reasonable to consider that the first phase commences from the time that the 2 Ukrainian naval vessels were contacted by Russian Coast Guard vessels on 24th November 2018. When considering the nature of the conduct of the parties in dispute, the Annex 7 Arbitral Tribunal considered 4 elements as shown in this slide. As regards the third element in particular, the Annex 7 Arbitral Tribunal noted that at the meeting of the United Nations Security Council of 26 November 2018, Ukraine characterized the matter as an act of aggression. Ukraine also requested that the detained servicemen be treated as prisoners of war. In light of this, the Arbitral Tribunal considered that at the time, Ukraine perceived the confrontation to have been a military one. According to the Arbitral Tribunal, the Russian Federation also saw this matter as a military confrontation. In conclusion, the Arbitral Tribunal rules that the events of the first phase constitute military activities. Accordingly, the Arbitral Tribunal has no jurisdiction to deal with the matter in the first phase. The second phase starts from the time that the Ukrainian vessels began to leave the anchorage area and were ordered to stop, and continued until the Ukrainian vessels were boarded and the vessels and their crews were arrested. The question is, when military activities ended? In this regard, the Arbitral Tribunal suggested 2 possibilities. According to the first possibility, at the point when the Ukrainian vessels began to leave the territorial sea in order to return to Odessa, the actions of the Russian vessels took on a law enforcement character. According to the second possibility, at the point when the Ukrainian vessels were boarded and arrested, the military activities ended. the scope of the jurisdiction of the arbitral tribunal would differ according to the selection of point when military activities ended. Should the arbitral tribunal took the first possibility, firing at the Ukrainian naval vessel would constitute a law enforcement activity and thus fall within the scope of the jurisdiction of the arbitral tribunal. This interpretation seems to be echoed by ITOS. If the first possibility were taken at the stage of merits, the arbitral tribunal would have to decide the legality of the use of force by the Russian authorities. Should the arbitral tribunal take the second possibility, however, the use of force by the Russian authorities would be considered as military activities. A precedent on this matter may be provided by the Guyana versus Suriname arbitration. In this case, the Annex 7 arbitral tribunal applied the unavoidable, reasonable, and necessary test. This test may provide an insight into the evaluation of the nature of the use of force by the Russian vessel. In any event, the arbitral tribunal considered that it needs further elucidation of this matter by the parties to reach a conclusion on this matter. Accordingly, the tribunal postponed that decision to the merits. The third phase commences at the end of the second phase, which is the arrest of the Ukrainian vessels and covers the continued detention of the vessels and their crews and the prosecution of the Ukrainian servicemen. According to the arbitral tribunal, the Russian Federation had decided by this time to subject the Ukrainian servicemen to domestic law enforcement processes. In light of this, the arbitral tribunal considered that the third phase did not involve military activities. The three phases of the dispute can be summarized in this slide. On the basis of the consideration, now we will compare the Annex 7 arbitral tribunal's approach to that of ITOS. As noted earlier, an essential feature of the ITOS approach is to decide the nature of the Ukraine versus Russian dispute in a comprehensive manner. Under this approach, a sequence of events that generated the dispute are considered as a unit. Here, a temporal element, namely the change of the nature of actions of the parties, does not come into play. By contrast, the key feature of the Annex 7 arbitral tribunal's approach consists in the temporal element. According to the arbitral tribunal, the nature of dispute may change over time in light of the interaction between the parties. In this regard, it can be observed that the arbitral tribunal's approach essentially differs from the approach taken by ITOS. Needless to say, we have to pay attention to the difference between the proceedings of provisional measures and those of preliminary objections. At the stage of the proceedings of provisional measures, the task of ITOS is to confirm the prima facie jurisdiction of the Annex 7 arbitral tribunal. As ITOS stated in the Ara Libertad case, the tribunal does not need to definitely satisfy itself that the Annex 7 arbitral tribunal has jurisdiction over the dispute submitted to it. Even so, it cannot pass unnoticed that there are some differences between ITOS and Annex 7 arbitral tribunal with regard to the evaluation of the Ukraine versus Russia dispute. Here, two observations can be made. First, it appears that the weight given to relevant factors differs between ITOS and the Annex 7 arbitral tribunal. It seems that ITOS didn't give much weight to the type of vessels, even though it didn't deny its relevance. However, the Annex 7 Arbitral Tribunal noted that vassals of a state, namely Ukraine, contested Russia's claim in its territorial sea, and that Russian Coast Guard vessels were joined by a naval vessel from the Russian Black Sea Fleet and military helicopters. Here, the arbitral tribunal seemingly gave more weight to the type of vessels. Furthermore, ITROS gave little weight to the characterization of the dispute by the parties. When considering the events of the first phase, however, the Annex 7 Arbitral Tribunal seemed to give much weight to the perception of the parties regarding the nature of the dispute. Second, the Annex 7 Arbitral Tribunal's evaluation of the nature of actions of the parties also differs from that of ITROS. ITROS clearly held that at the core of the dispute was the parties' differing interpretation of the regime of passage through the Kerch Strait, and that such a dispute is not military in nature. Related to this, the Annex 7 Arbitral Tribunal in the 2020 Ukraine versus Russia Arbitral Award also held that the fact that some of the Ukrainian vessels whose navigation was impeded belonged to Ukrainian Navy does not cause the dispute to concern military activities. By contrast, as explained earlier, the Annex 7 Arbitral Tribunal in the 2022 Ukraine versus Russia Arbitral Award rules that the matter of the first phase, including the prevention of navigation of the Ukraine naval vessels, involved military activities in the meaning of Article 298, paragraph 1b. Furthermore, ITROS in its order has already expressed the view that force was used by the Russian Federation in the context of a law enforcement operation. This view seems to be echoed by the 2020 Ukraine versus Russia Arbitral Award concerning coastal state rights in the Black Sea, Sea of Azov, and Kerch Strait. In the 2022 Arbitral Award, however, the Annex 7 Arbitral Tribunal postponed the decision on this matter to the merits because it needs further elucidation of this matter by the parties. Under the chronological approach taken by the Annex 7 Arbitral Tribunal, the distinction of phases of a dispute is key. Here, an issue that arises is how we can divide an international dispute into multiple phases. It can be considered that normally a turning point, that is a point when the nature of actions of the parties changed from military action to law enforcement activities, provides a point that distinguishes one phase from another phase. As shown in the second phase in the Ukraine versus Russia dispute, however, the identification of a turning point may be less easy. In any event, the validity of the chronological approach rests on the manner of division of distinct phases of dispute in question. By way of conclusion, I'd like to make two comments. Under the overall assessment approach taken by ITROS, the nature of state activities is to be evaluated comprehensively, taking into account the relevant circumstances as shown in this slide. Eventually, a dispute as a whole is to be characterized as either a military activities dispute or a law enforcement dispute. However, normally, international disputes are multifaceted, so when considering a mixed dispute involving both military and law enforcement elements, a threshold for deciding the nature of actions of the parties is particularly important. In this regard, there is a need to establish a reasonable standard, avoiding an extremely low or high threshold. Second, the Arbitral Tribunal, in its Arbitral Award of 2022, took the chronological approach. According to this approach, a sequence of events that gave rise to a dispute are to be divided into multiple phases, and the nature of actions of the parties are examined in each phase. While there is no general criteria for dividing events into multiple phases, a point when the nature of actions of the parties changed from military activities to law enforcement activities can provide a point that distinguishes one phase from another phase. Overall, it may have to be admitted that still the interpretation of military activities under Article 298, paragraph 1b of the Law of the Sea Convention remains fluid. Further accumulation of case law will be needed to elaborate the interpretation of military activities. Given that disputes regarding the military activities may be a threat to the maintenance of international peace and security, clarification of the meaning of military activities should be a crucial issue that needs further consideration in the international law of the sea. Thank you very much for your attention.
Thank you very much, Professor Tanaka, for your interesting comparative approach to the quest for a proper interpretation of military activity.